Good evening. I'm Robert Dijkgraaf, the Director and Leon Levy Professor at the Institute for Advanced Study, and it's my great pleasure to welcome you to this annual public policy lecture. In fact, it's the sixth lecture in a series. These annual lectures were created to bring to the Institute public discussion of contemporary issues with great relevance to society. Previous speakers were Lakhdar Brahimi on Afghanistan and Iraq, Mary Robinson on human rights challenges, David Cole on torture and accountability in the war on terror. We had James Hansen on human-made climate change, and last year, Maud Borlow on the global water crisis. And it's a great honor and pleasure to announce today's lecture, which is from Professor Owen Fiss, Sterling Professor Emeritus of Law and Professorial Lecturer in Law at the Yale Law School. Professor Fiss is a highly influential constitutional scholar and teacher, and for over 40 years he had taught widely praised courses in law and legal theory, and is author of some of the most cited law review articles of all time. He was educated as an undergraduate at Dartmouth and the University of Oxford, where he was a Fulbright scholar. After receiving his law degree from Harvard Law School, he clerked for Thurgood Marshall, when Marshall was a judge on the US Court of Appeals for the Second Circuit. He next clerked for William Branham on the United States Supreme Court. He also served as special assistant in the Civil Rights Division of the US Department of Justice. Professor Fiss began teaching at the University of Chicago in 1968 and moved to Yale in 1974. In addition to his work, well-praised work in academia, he served as an international advisor on creating and strengthening constitutional democracies. He received honorary doctorates from the University of Toronto, the University of Buenos Aires, and the University of Palermo in Buenos Aires. And he was awarded the Distinction Socrates from the University of the Andes in Colombia. He is a fellow of the American Academy of Arts and Sciences. He is a prolific author with many books and articles that cover topics as diverse as the history of the Supreme Court, freedom of speech, fairness in employment law, the legacy of racism in American cities, and constitutional protections for new immigrants. Today's speaker's influence comes not only from his great expertise in the law, but also in his firm belief in the power of the legal system to offer true justice in society. As a colleague and former student put it, to Owen, constitutional law and education is more than just an object of scholarly pursuit. It's an ideal of behavior between the state and the individual. The adjudicative process is a method of giving meaning and content to our social values. Today, he will address constitutional rules on telephone privacy in this 2012 public policy lecture titled The Lives of Others. Please join me welcoming to the stage Professor Owen Fiss. I should tell you that after the lecture we have some time for questions and answers.
Thank you very much. Protecting the privacy of telephone calls has recently become an urgent public project. It reflects my commitment to a constitutional value that has long been one of the sources of our national identity, but is now endangered. It is also premised on my belief in the continuing importance of the telephone as a means of communication. Many of the exchanges that once took place on the telephone now occur through emails. This is especially true of the communications that typically occur between professional colleagues or business associates when the purpose is to convey information, issue a directive, or render an opinion. The telephone is still used, however, when a conversation is needed, for through the transmission of the human voice, it permits direct, highly interactive, and sometimes spontaneous engagement with others. Relatively recent technological advances employing the personal computer even permit the transmission of the images of the parties to the conversation. The telephone became a regular feature of American social life in the decades immediately following the Second World War. In more recent years, as the pace of globalization has accelerated, we have increasingly come to rely on the telephone to have conversations with friends, family, or business associates now scattered throughout the world. At the same time, technological changes, above all the development of the cell phone, have enhanced the convenience of placing or receiving a telephone call. For most of the 20th century, the telephone was a stationary device located in the home or office or in a publicly accessible phone booth. Today, the telephone is mobile and can be carried easily wherever one happens to be. Engaging in a personal conversation is not like writing a diary. We may assume that the thoughts or sentiments expressed in the conversation remain with the person with whom we are speaking, but that assumption may well be mistaken. This is so even in a face-to-face encounter. The person with whom we are speaking may turn around and share the contents of that conversation with others. Although such a risk is present in a conversation conducted over the phone, this mode of communication presents yet another threat to the privacy of a conversation. And it derives from the fact that the conversation is being electronically transmitted. A third party may obtain access to the transmission and listen to and record whatever is said. As the telephone became more ubiquitous and telephone conversations became more commonplace, the law sought to guard against the dangers of such interceptions by a third party, which, due to the technology initially employed to transmit telephone signals, became known as wiretapping. Starting in 1934, Congress prohibited private parties from ever wiretapping. Although there was a question whether government officials were covered by this law, in 1967, the Supreme Court took a bold step forward and construed the Fourth Amendment to limit the authority of federal officials to eavesdrop in this way, requiring them to go before a judge and obtain a warrant authorizing the interception. The statutory prohibition against wiretapping by private parties remains unqualified and appears today as a fixed feature of the legal landscape. Yet, the constitutional rule protecting the privacy of telephone conversations from government interceptions is now in a shambles. This turn of events is in part attributable to the reluctance of the Supreme Court in recent decades to safeguard fully and forcefully the values protected by the Fourth Amendment. Even more, it is attributable to the events of September 11th, 2001, which generated enormous pressure to compromise fundamental principles and thus has given rise, in the eyes of some, to a new age of American law. Soon after the September 11th attacks, President George W. Bush declared a war on terror and gave concrete meaning to that call by launching a military campaign against al-Qaeda, that far-flung terrorist organization that was responsible for those attacks. At the same time, he invaded Afghanistan when that government, then controlled by the Taliban, refused to turn over Osama bin Laden and other leaders of al-Qaeda who were harbored there. In the context of this military campaign, President Bush issued a number of directives as Commander-in-Chief. The most notorious of these orders governed the treatment of persons captured on the battlefield. Yet some had a direct and immediate impact on the quality of life in the United States, though they too were issued pursuant to his powers as Commander-in-Chief. One of the most striking of these orders, issued in the fall of 2001, established the so-called terrorist surveillance program, which directed the National Security Agency to tap international telephone calls between persons in the United States and persons abroad who were suspected of having links to al-Qaeda. The interception of these calls was not authorized by a warrant or any other form of judicial approval. At its inception, the terrorist surveillance program was hidden from public view, which, given that its purpose was to catch the unwary, is not all that surprising. On December 15th, 2005, however, 4 years after this program was instituted, this program was publicly disclosed by the New York Times and soon became the subject of a heated public controversy. Although many objections were raised to the program, the principal one arose from the failure of the President to abide by the requirements of the Foreign Intelligence Surveillance Act, statute that I'll call FISA for most of this lecture. This statute was enacted by Congress in 1978 in the wake of revelations of a Senate committee headed by Senator Frank Church about the far-reaching and largely uncontrolled surveillance activities of American intelligence agencies. As originally enacted, the statute required the executive to obtain the permission or authorization from a special court before tapping the phones of agents or employees of a foreign power. The membership of this court was to consist of 10 sitting federal judges who were to be specially designated for this assignment by the Chief Justice. Each of these judges was authorized to act alone. Their identities were to be kept secret, and so were their proceedings. The 1978 statute defined a foreign power to include not only a foreign nation, but also a group engaged in international terrorism. The statute further provided that foreign intelligence information included information related to clandestine intelligence activities, sabotage, international terrorism, and the conduct of the foreign affairs of the United States. The Act declared that the procedures that it established were to be the exclusive avenue for gathering foreign intelligence. Bush's Attorney General, Alberto Gonzales, defended the President's refusal to abide by the procedures of the 1978 statute. To do so, he invoked the resolution that had been passed by Congress on September 18, 2001, authorizing the use of military force against those responsible for the September 11 attack. He claimed that this resolution had implicitly modified the provisions of the 1978 statute that made it the exclusive procedure for intercepting the telephone calls of the agents of a foreign power. In Gonzalez's view, the 2001 resolution had removed any conflict between the terrorist surveillance program and the 1978 FISA statute. Gonzalez did not, however, stop at this point. He also denied, and this is important, he also denied that Congress had the power to interfere with the effort of the President to discharge his duties as Commander-in-Chief. Article 2 of the Constitution vests the President with the authority and responsibility to act as Commander-in-Chief, and he thus has, according to Gonzalez, the authority, the constitutional authority, to override the provisions of any statute that, in his judgment, unduly interfered with the discharge of these duties. Congress cannot tell the President how to deploy the armed forces, and similarly, Gonzalez continued, Congress cannot instruct the President in his efforts to gather intelligence needed for the successful completion of the military campaign. Not surprisingly, the constitutional issue was more complicated than Gonzalez allowed. True, Article 2, which enumerates the power of the President, says that he is Commander-in-Chief of the armed forces. But the Constitution also grants Congress war powers. Article 1 gives Congress the authority to declare war, make general regulations governing the armed forces, and to appropriate funds for the military. In the domain of war, many of the powers of the President and Congress are shared or overlapping, and it is difficult to know who should prevail when there is a conflict. In the end, the nation was saved from the difficulty in resolving this conflict between the President and Congress. In January 2007, after a year-long public debate, the Attorney General changed his strategy. He turned to the FISA court. In a letter to the chairman and ranking minority members of the Senate Judiciary Committee, the Attorney General reported that on January 10th, 2007, a judge on the FISA court had issued orders authorizing the wiretapping covered by the terrorist surveillance program. The Attorney General also said that in light of this turn of events, the President had determined that there was no need to continue the terrorist surveillance program, although the Attorney General ended his letter by affirming his belief that the program fully complies with the law. Factions within the Bush administration soon grew uneasy with this newly announced willingness of the Attorney General to submit to the requirements of FISA. On April 13th, 2007, only months after Gonzalez's letter to the Senate Judiciary Committee, the administration introduced legislation that would, in its terms, modernize FISA, or put otherwise, would give the intelligence agencies all the powers they thought they needed. Congress responded favorably to the administration's overture, first on August 5th, 2007, when it passed the Protect American Act. That law was conceived as a temporary measure and expired on February 16th, 2008. Then, on July 10th, 2008, Congress enacted the replacement statute. It too was conceived of as an amendment of the 1978 statute, and thus appropriately named the FISA Amendments Act of 2008. It essentially allowed FISA judges to authorize wiretaps on the terms and conditions proposed by the administration. This statute is scheduled to expire in the end of this year, but there's every reason to believe that it'll be renewed. Although the 2008 statute was sponsored by President Bush and historically connected to his terrorist surveillance program, it has been endorsed by his successor. As a senator, Barack Obama opposed the provision of the 2008 statute that gave immunity from civil suits to the telephone companies that had participated in the original terrorist surveillance program. Obama lost that fight, and although he did not cast a vote on the 2008 statute itself, remember at this point he's a senator, his Attorney General, Eric Holder, declared at his confirmation hearing in January 2009 that he would defend the constitutionality of the statute. Soon after the 2008 statute had been signed into law, a suit challenging it was filed, and that suit was pending at the time of Holder's confirmation hearing. Holder's assurance to the senators in this confirmation hearing should not be understood as a grudging recognition of a ministerial duty. Rather, it should be seen as the expression of the broad policy position of the administration, the Obama administration. A willingness, perhaps a reluctant willingness, but a willingness to continue most of Bush's counterterrorism policies. President Obama has studiously and consistently avoiding using the phrase war on terror, but he has repeatedly declared that the United States is at war with al-Qaeda, a position he maintained even after Osama bin Laden was killed in May 2011. Admittedly, on January 22nd, 2009, the day after his inauguration, Obama issued executive orders that sought to minimize the risk of torture in the interrogation of suspected terrorists. He imposed the Army Field Manual on the CIA and closed secret prisons, the black sites that the CIA had maintained. He also ordered that the prison at Guantanamo should be closed in a year's time. Congress has blocked the implementation of this order, but the significance of closing Guantanamo soon became, at least to me, unclear. Since in May 2009, in his now famous National Archives speech, Obama embraced key policies that in part gave rise to the notoriety of the Guantanamo prison. Prolonged, indefinite detention without trial of some of the prisoners being held there, and the use of military commissions to try others. In conducting the war on terror, Bush sometimes, most notably in the context of interrogating suspected terrorists and in the context of wiretapping, claimed the power to act in ways that violated congressional mandates. Obama has never claimed such a power. He has not defied Congress, but neither has he waited for specific congressional directives for his action. He too has been proud of his powers as commander-in-chief and has rode them to the full. In defending some of his policies, like imprisonment without trial and targeted killings, Obama has pointed to the congressional resolution of September 18, 2001, which authorized the use of force against those responsible for the attacks of September 11. But this practice did not differentiate him from Bush, who, as we saw, also treated the September 18th resolution as the congressional authorization for the war he began against al-Qaeda and Afghanistan, and thus as the foundation for his exercises of the powers of Commander-in-Chief. At the moment, the Obama administration is trying to block judicial review of the 2008 surveillance statute by denying that the plaintiffs in the suit that was filed immediately after it was enacted have standing to challenge it. That is, they do not have the right, he claims, to have a court pass on the validity of the statute. The plaintiffs consist of a group of lawyers, journalists, and human rights researchers who have professional interest in the Middle East and who regularly have been in touch with persons in the region who might be thought to be terrorists. One of the lawyers represents Khalid Sheikh Mohammed, the alleged mastermind of the September 11 attacks, who is now being tried before a military commission at Guantanamo. The Court of Appeals for the Second Circuit found that there was a substantial risk that the plaintiff's telephone calls would be intercepted and that the plaintiff had to adjust their action accordingly to avoid that risk. For example, by speaking in more guarded ways or traveling to the region to have face-to-face conversations with possible witnesses. To insist upon more, namely that the plaintiffs show that their telephone calls were in fact intercepted, would, given the secret nature of such surveillance, mean that virtually no one would have standing to challenge the validity of the statute. The Second Circuit held that the plaintiffs had standing and remanded the case to the district court. At this point, almost 4 years after the statute was enacted, one would have assumed that the case would then be transferred to the district court for a ruling on the merits. But Obama sought review of the Second Circuit decision in the Supreme Court. An oral argument was held before the court this past October, just weeks ago. In this lecture, I put the standing issue to one side and instead take up the question of the validity of the 2008 statute, which the Obama administration is fully prepared to defend when and if the Supreme Court decides that the plaintiffs have standing to challenge it. The 2008 statute is unconnected to warfare. It was enacted during an era defined by the initiation of a war on terror, but unlike the terrorist surveillance program, it has no analytic connection to the fight against al-Qaeda or any other military operation launched in response to the events of September 11. As an amendment of the 1978 FISA statute, the act is linked not to war, but rather to the process governed by that statute, gathering foreign intelligence. The concept of foreign intelligence gathering emerged as a distinct legal category in a rather backhanded manner in the crevices of a back and forth between Congress and the Supreme Court on the constitutional rules that should govern wiretapping. The Supreme Court took the initiative in 1967 during the halcyon days of the Warren Court when it held in Katz versus the United States that the Fourth Amendment required government wiretapping to be authorized by a judicial warrant. In fashioning this rule, the court was driven by an understanding that conceived of the diffusion of powers among the various branches of government as a way of protecting freedom. It also drew upon the established rules governing intrusions into the home, long thought as a citadel of privacy. The warrant had to identify the target of the interception with particularity. The government also had to give under oath the reasons for believing that the individual had committed or was committing a crime or was about to commit one, or that the evidence of crime would be obtained by the interception. The court in the Katz case carefully noted the rather banal character of the case before it. It involved the prosecution of an individual who was charged with participating in a gambling ring. The court distinguished such a case from one involving issues of national security and specifically declined in the penultimate footnote to say whether warrants would be necessary in such cases. As the court put it, whether safeguards other than prior authorization by a magistrate would satisfy the Fourth Amendment in a situation involving the national security is a question not presented by this case. In 1968, soon after the Katz decision, Congress moved by a large public campaign to get tough on crime, passed the statute, the Omnibus Crime Control and Safe Streets Act of 1968. In Title III of that measure, Congress established rules governing wiretapping. It faithfully endorsed the Katz requirements and prescribed the procedures for obtaining warrants for wiretapping. It also ended with the proviso so similar to the Katz footnote that declared that nothing in this statute should be read as requiring a warrant in national security cases. In 1972, in the so-called Keith case, the court was called upon to consider this proviso of the 1968 Act. This case arose from the radical politics engendered by the Vietnam War and appeared on the court's docket at a time, said the court, of worldwide ferment and civil disorders. 3 individuals were charged with participating in a conspiracy to destroy government property. One of the 3 was also charged with blowing up a CIA office in Ann Arbor, Michigan. In response to a pretrial motion by this individual, the Attorney General filed an affidavit in which he acknowledged that federal officials had intercepted telephone conversations in which the accused had participated. The Attorney General also acknowledged that these wiretaps were not authorized by a warrant, although he went on to insist that the interception was a reasonable exercise of the President's power to protect national security and that a warrant was not required for such interceptions. By 1972, the Warren Court, understood as demarcating a distinct phase of American constitutional history, had begun to disintegrate. The personnel had begun to turn over. Lewis Powell, a recent Nixon appointee, wrote the opinion for the court. He began his analysis by putting Title III to one side. The proviso exempted the Attorney General in national security cases from the warrant requirement of the statute, but it was not read as a grant of authority. According to Powell, the provision left the Attorney General where it found him, that is, subject to the Fourth Amendment, which, recall, the court in Katz had not yet said is applicable to national security cases. However, rather than confronting head-on the question whether the Fourth Amendment applies to national security cases, Powell drew yet another distinction, arguably suggested by the proviso in Title III, between threats to national security posed by domestic organization, which he referred to throughout as domestic security matters, and to threats to national security posed by foreign powers or the agents. He then applied the Fourth Amendment warrant requirement to domestic security matters as he characterized the case before him, but in a manner so reminiscent of Katz, expressed no opinion, here I'm quoting, on the scope of the president's surveillance power with respect to the activities of foreign powers within or without this country. The 1978 FISA statute sought to fill the decisional space first created by the court in Katz and then narrowed in Keith. The statute established a procedure that required the Attorney General to apply to a special court for permission or authorization to intercept telephone calls, both domestic and international, that were being transmitted through facilities located in the United States. This requirement of prior court approval that's created by the FISA statute should not, however, be confused with the warrant requirement imposed by the court in Katz and Keith. FISA did not require, as those two decisions had, that the government set forth reasons for believing that the target of the tap was guilty of a crime or that the tap was likely to produce incriminating evidence. The government need only set forth reasons for believing that the target of the tap is an agent or employee of a foreign power and that the interception was likely to secure foreign intelligence, which, recall, is broadly defined by the statute as information that could be, but need not be, related to criminal activity such as sabotage or international terrorism. By the terms of the 1978 statute, foreign intelligence may relate to alleged clandestine intelligence activities, or even more significantly, the conduct of foreign affairs. As a result of the 1978 statute, a dual structure emerged for wiretapping. Some interceptions require warrants based on probable cause as defined by Katz and Keith. Others, though specifically designed to gather in foreign intelligence, do not. Remarkably, to this day, almost 35 years later, the Supreme Court has not ruled on the constitutionality of the FISA scheme and the dual structure for wiretapping that it created. Yet a number of lower courts upheld the statute, and they then had to face a new quandary. Could the transcript of a telephone conversation obtained through FISA procedures be admitted into evidence in a criminal prosecution? These lower courts could have held that the probable cause requirement of Katz and Keith had to be satisfied whenever the result of a wiretap was to be introduced in a criminal prosecution. They chose, however, a more permissive rule and defined it in terms of the purpose of the interception. As long as the primary purpose of the tap was to gather foreign intelligence, the government could use the less demanding FISA procedures for obtaining court permission and then use the results of that interception in a criminal prosecution against the target of that tap, even though the permission was not based upon a showing of probable cause. This ruling lessened the force of the rules governing wiretaps that the Supreme Court had announced in Katz and Keith, a trend that continued with the passage of the USA Patriot Act in the immediate wake of September 11th. The Patriot Act provided that foreign intelligence gathering only had to be a significant as opposed to a primary purpose of the interception in order for the less demanding FISA procedures to govern. As a practical matter, this enabled the government to avoid the Fourth Amendment warrant requirement proclaimed by Katz and Keith whenever it had reason to believe that the target of the interception was an agent or a foreign power and that foreign intelligence would be gathered by the interception. Gathering foreign intelligence could be a significant purpose of an interception and thus legitimate under the less demanding FISA procedures, even if the primary purpose of the interception was to gather evidence for a criminal prosecution. The 2008 statute preserved the changes to FISA effectuated by the Patriot Act. The government need only show that the gathering of foreign intelligence is as significant as opposed to a primary purpose of the wiretap. The 2008 statute also continued the original FISA requirements for authorizing wiretaps in which the target is a person located in the United States. In these cases, the government must, in addition to the significant purpose showing, establish a reason for believing that the target is an agent or employee of a foreign power. However, the 2008 statute introduced a further complexity by establishing, as the Bush administration had proposed, a special set of rules to apply when the target of the tap is located outside the United States. Now, some of these persons abroad may be Americans. With respect to them, as with Americans within the United States, the requirement of the 2008 Act for surveillance are in accord with the original FISA statute as amended by the Patriot Act. The government must establish that a significant purpose of the tap is to gather foreign intelligence and that the individual is an agent or employee of a foreign power. These requirements apply regardless of whether the interception is effectuated through facilities located in the United States or facilities abroad. However, in the case of foreigners who are located abroad, the 2008 statute radically departs from the original FISA standards. Permission by a FISA judge is required whenever access for the interception is obtained through facilities located in the United States, but the traditional FISA standard governing this process is drastically lowered. Lowered indeed almost to a vanishing point. Although the government must state that a significant purpose of the tap is to gather foreign intelligence, little more is required. The government need not have reason to suspect that the targets of the tap are agents or employees of a foreign power, only that they are foreigners and that they are located outside the United States. The 2008 Act not only lowers the standards for authorizing wiretaps aimed at specific foreigners abroad, it also facilitates the issuance of blatant authorization for taps of such persons, much as Bush's terrorist surveillance program did. Even though the entire FISA procedure is cloaked in secrecy, the 2008 Act relieves the government of the need to disclose to a FISA judge the identity of each individual to be targeted. It only requires that the government describe and employ procedures reasonably designed to ensure that its proposed surveillance activity will only target foreigners abroad. Arguably, this might permit the government to obtain authorization from a FISA judge to tap the telephone calls of an entire group of foreigners, of foreign nationals abroad. For example, persons suspected of links with Al-Qaeda, or for example, high-ranking officials of the Pakistan Army. All applications for warrants, even those required by the Supreme Court's decision in Katz and Keith, are considered by a judge without notice to the target. The hope is that a judge, acting on his or her own, will scrutinize the factual basis of the government's application for a warrant. This hope for such independent judicial judgment arguably remains even in the original FISA scheme, though the chances of it materializing are lessened by the fact that the federal judges who exercise the powers of the FISA court are specifically designated by the Chief Justice and further are protected by a cloak of anonymity. However, the 2008 Act goes beyond this. It provides that the FISA judge must approve the application sought if the supporting certificate filed by the Attorney General and the Director of National Intelligence contains all the required elements. there is no room for the judge to scrutinize, as he or she might have done in the past, and as any federal judge must, the factual predicates of the government's FISA application. The constitutional protection of privacy has never been an absolute. The Fourth Amendment does not altogether deny the government access to information it needs, but rather restricts the techniques and methods that the government may employ to acquire that information. It places a zone around domains and activities of the individual, those endowed with a reasonable expectation of privacy, and then constructs a barrier to protect this zone. This barrier is reinforced by the understanding that each intrusion not only impairs the individual's interest in privacy and thus undermines the conditions necessary for human flourishing, but also may, given the particular circumstances of the intrusion and the reasons for it, threaten a multitude of other constitutional interests, including political freedom, fair trial, and equal treatment. The 2008 statute is a grant of authority. It allows the government to intercept telephone conversation and thus to interfere with an activity most certainly endowed with the reasonable expectation of privacy. The validity of this measure turns on the conditions the statute imposes on the exercise of this authority, and whether those conditions are stringent enough to comport with the Fourth Amendment and the barriers it interposes against such intrusions of privacy. The barriers constructed by Katz and Keith to wiretapping has two features. It requires court approval prior to the interception, and it conditions that approval upon a showing of probable cause. FISA, as originally enacted and as amended in 2008, satisfies the first requirement of prior court approval, but it qualifies in important ways the second to show probable cause. The Fourth Amendment does not elaborate on the meaning of probable cause, but as Katz and Keith and countless other cases declared, probable cause, as used in the Fourth Amendment, is a technical term linked to criminality. It does not simply mean reason to believe, but rather reason to believe that the person whose calls are being intercepted had committed a crime, is committing a crime, or is about to commit a crime. Now, the burden of showing probable cause may weigh heavily on the government. In some cases, the government may need to wiretap in order to acquire the information that will enable it to identify a suspected criminal or to give it reason to believe that an individual is about to commit a crime. Under the Fourth Amendment, however, that information must be secured by ways that do not entail intercepting a conversation that the individual has every reason to believe is private. Yes, in Katz, again in Keith, the Supreme Court stopped short of applying this interpretation of probable cause to interceptions aimed at gathering foreign intelligence and reserved that question for another day, a day that has not yet come. It is difficult, however, to understand how that term could have different meanings depending on the type of information sought, the purpose of the government is seeking this information, and the nationality and location of the person who is the target of the interception. Soon after the enactment of the 2008 FISA amendments, a lawsuit, the one now before the Supreme Court, dealing with the issue of standing, was filed challenging the statute. This lawsuit was designed to focus attention on the provisions of the 2008 statute regarding foreigners abroad and it did so with good reason. Those provisions mark the clearest and most disturbing department from the Fourth Amendment's probable cause requirement. In fashioning these provisions, however, President Bush and Congress may have been relying on a 1990 decision of the Supreme Court in the United States versus Verdugo-Iquides, which might be read as placing foreign nationals abroad beyond the protection of the Constitution. In Verdugo-Iquides, William Rehnquist, then Chief Justice, denied the protection of the Fourth Amendment to a Mexican citizen who had been kidnapped, had been forcibly taken to the United States to stand trial on drug charges, and whose home in Mexico had been searched by United States drug enforcement officials without a warrant. According to Rehnquist, the Fourth Amendment, and perhaps the entire Bill of Rights, provides no protection to foreigners abroad, and thus did not govern the search of the Mexican citizen's home in Mexico. In my view, this imagined reliance on Verdugo-Iquides by the sponsors of the 2008 measure, it is misplaced. It overlooks Justice Kennedy's concurring opinion, which set forth a pragmatic but more cosmopolitan understanding of the reach of the Constitution. Kennedy, whose vote was essential for Rehnquist, was led by pragmatic concerns to dispense with the need for a warrant to conduct a search of a home in Mexico, but nevertheless insisted that the action of U.S. officials, wherever they act, and against whomever they act, must, within the framework of the Fourth Amendment, be reasonable. Even more, this imagined reliance on Verdugo-Iquides by the sponsors of the 2008 measure overlooks Kennedy's opinion, this time for the majority, in the 2008 Boumediene versus Bush decision, which made the writ of habeas corpus available to Guantanamo prisoners, all of whom are foreign national. We need not, however, enter into the debates generated by these reading of Kennedy's opinion. For even if we adopt Rehnquist's position in Verdugo-Iquides, even if we restrict the protection of the Fourth Amendment in the way that he does, there is good and sufficient reason to be concerned with the surveillance authority granted the executive by the 2008 statute, simply because Americans may well be parties to those calls, and the interception of these calls will interfere with the reasonable expectation of privacy of the Americans. The focus, I insist, should not be restricted to the target of the interception, but rather should embrace all the parties to the conversation. The 2008 amendments require court authorization of a tap aimed at foreigners abroad only when the interception entails access to facilities located in the United States. Although sometimes conversation between two foreigners located abroad may be routed through facilities in the United States, this is rare. The bulk of international telephone calls routed through the United States involve at least one party who is in the United States. Some of these persons may be transitory visitors or even persons in the country illegally, presumably beyond the protection of Rehnquist's Fourth Amendment. But more likely than not, they will be United States citizens or persons lawfully granted residence in the United States, persons who had the voluntary connection to the United States that Rehnquist demanded in Verdugo-Iquides. Accordingly, a wiretap authorized by a FISA judge that is aimed at a foreign national living abroad will, in all likelihood, give the government access to private conversations of persons unquestionably entitled to protection of the Fourth Amendment. This is indeed true of the plaintiffs in the standing case now before the Supreme Court, journalists, lawyers, and human rights researchers whose work necessitates frequent and regular telephone calls to people in the Middle East. These plaintiffs may not be the target of the surveillance, and for that reason may be characterized as incidental victims of the surveillance. But there can be no mistake that they are victims of the surveillance, just as much of their personal or private information may be acquired as that of foreign national living abroad. In criticizing the 2008 amendments, and perhaps the 1978 FISA scheme in general, for failure to abide by the probable requirements of the Fourth Amendment, I am making little, perhaps too little, of the considered judgment of Congress and President over the meaning of that crucial term. It's difficult, however, to endow the decisions of the President and Congress with the normative force that derives from our democratic commitments. The meaning of the term probable cause is a highly technical issue. The meaning given to that term by the political branches can only be found in long, complicated statutes not easily accessible or understood by the general public, or maybe even by the representative. Moreover, the burden of the FISA scheme, dilution of the probable cause requirement, is in large part, though not entirely, shouldered by persons who are not entitled to participate in the electoral process. This is particularly true of the 2008 amendments and its grant of authority to target the telephone calls of foreigners located abroad. Granted, the President, Congress, are coordinate branches of government, also charged with the duty of giving concrete meaning to the Constitution, but they are not bound by the strictures of public reason, above all, the rule requirement judgment based on principle that gives the judiciary the authority to interpret the Constitution and, if need be, to override the interpretation of the political branches. The Fourth Amendment has an unusual grammatical structure. It consists of two clauses joined by the word "and." The first clause proclaims the right of the people to be protected against unreasonable searches and seizures. The second sets forth the requirements for warrants. Some scholars have advanced a disjunctive reading of the two clauses, arguing that in the minds of the framers, the warrant clause sought to limit the availability of warrants, not to make their issuance decisive in determining whether interception is within the meaning of the first clause reasonable. The possession of a valid warrant, the argument goes, would provide an absolute defense for a government official who might be subsequently accused of conducting an unreasonable search and sued for this action. By tightly prescribing the requirements of valid requirement, the Fourth Amendment sought to limit the issuance of warrants and correspondingly the availability of an absolute defense for unreasonable searches. This understanding of the warrant clause may be a plausible account of the historic origins of this provision. But even so, it does not undercut the now ancient rule affirmed by Katz and Keith in the context of wiretapping and countless other cases involving other contexts, requiring that if at all possible, the government seek a warrant before conducting a search that violates a reasonable expectation of privacy, and further that the warrant be issued only if certain requirements, including the showing of probable cause, are satisfied. Indeed, this ancient rule may be a fair implication of the bar on the defensive use of warrants that do not meet the specified standards. Liability rules often reflect an understanding of best practices. In the years following Katz and Keith, a number of cases in which an exception to the warrant requirement has been made has grown and now embraces such diverse practices as building code inspections or the searches of passengers and their luggage at airports. These exceptions have been grouped under the heading special needs and have typically been justified on the ground that the intrusion of privacy is momentary, obtaining a warrant before the search is not remotely practical, and redress of abuses of power may be obtained through an action for damages. These conditions are clearly not satisfied by FISA wiretaps. Such surveillance is not a momentary intrusion, but lasts for a considerable period of time. Nor can it be claimed that obtaining a warrant prior to surveillance is a practical impossibility, as it might be in the case of airline security checks. And given the secrecy requirements of a FISA scheme, a retroactive action for damages for abuses of executive power is not a viable alternative. In an era that began with the terrorist attacks of September 11, 2001, and continued with the bombings in London and Madrid, and a number of failed bombing plots in the United States, the temptation is great to expand the special needs exception that I've just discussed to embrace surveillance activities at preventing further terrorist activities. The special needs would arise, the argument might go, simply from the magnitude or severity of the harm that the government is seeking to avoid. Such an approach would require that a distinction be made between extraordinary and ordinary crimes. It may be difficult to formulate the criteria needed to implement such a distinction, but my concern with this approach runs even deeper. For one thing, I fear that an exception to the warrant requirement for extraordinary crimes would be susceptible to great abuse. The government can always claim that it is seeking to prevent an extraordinary crime and then defend that claim on the basis of knowledge or information that it alone has. Even more, I fear that such an approach would impair the authority or near sacred quality of the Constitution as a charter establishing the structure of government and defining the highest ideals of the nation. It would also put the judiciary into the business of making exceptions to a standard rule that is not easily cabined or consistent with their obligation to say what the law is. Pragmatic considerations often enter into judicial judgment, but never in a way that permits disregard for a clearly established constitutional command or interpretation. However, even if a new expansion of the special needs doctrine were allowed for extraordinary crimes, it is hard to see how it might save the 2008 amendments or even the FISA scheme in general. These statutes, in contrast to President Bush's terrorist surveillance program, are in no way limited to surveillance that is aimed at al-Qaeda and its allies or international terrorism in general. As originally enacted, the 1978 FISA statute defined a foreign power to include a group engaged in international terrorism, and then defined foreign intelligence in a way to include information about international terrorism. Yet the statute is not confined to terrorism and includes within the category of foreign intelligence any material related to the conduct of the foreign affairs of the United States. In utilizing the powers, in the context of the First Amendment and its guarantee of freedom of speech, we have learned to judge statutes on the face, on the basis of all their possible applications. Under the so-called overbreadth doctrine, The court will strike down statutes that arguably may have some constitutionally permissible applications if there are a substantial number of applications that impinge on the activities that are concededly constitutionally protected. Declaring the statute on its face will enlarge the freedom of citizens to participate in those activities that are constitutionally protected. At the same time, legislators will remain free to prohibit the activities that may be constitutionally unprotected, but now only in a way that narrowly targets those activities and thus economizes on the sacrifice of freedom. A similar doctrine, I argue, needs to be recognized in the context of the Fourth Amendment. In the First Amendment context, the overbreadth doctrine was announced as a protection against the chilling effect of a criminal statute. The 2008 amendments, as well as the original FISA statute, is a grant of authority to government agencies, the executive and the judiciary, not a criminal statute addressed to ordinary citizens. Yet such a grant of authority may have the effect of discouraging, of chilling the exercise of personal liberty, in this instance, the liberty to engage in private telephone conversation. Thus, even if there are some offenses that are so extraordinary that we may allow the government to investigate them without a warrant, the statute that permits or authorizes such investigative activity must fall when it embraces as broad a category as foreign intelligence gathering. The legislators must go back to the drawing board. They must go back to the drawing board and come up with a statute confined to investigations related to international terrorism or some other horrendous acts of violence. Then, but only then, will the Supreme Court have to decide whether the crime being investigated is such an extraordinary offense and whether such an offense justifies an abandonment of the traditional and general requirements of the Fourth Amendment. One branch of the principle requiring separation of powers warns against unilateral exercises of executive power. From this perspective, the 2008 statute, compared to the 2001 surveillance program, might be seen as a step forward, or maybe a half step. In it, the role of the judiciary is minimized, but Congress authorized what Bush had decreed. From the perspective of the Fourth Amendment and the values it seeks to protect, the 2008 statute strikes me as a step backward. For its authorization of warrantless wiretapping is in no way confined to terrorism or to the investigation of any other offense that might plausibly be regarded as extraordinary. This means that, like much of what happened during the last decade, such as the use of military commissions and prolonged indefinite imprisonment without trial, the 2008 statute has transformed the exception into the rule. At the moment, the authority to engage in warrantless wiretapping is confined to the process of gathering foreign intelligence. But if left unchecked, it will create the pressure for a similar authority in other realms, and I fear it may well become a new point of departure. Thank you.